Okay. Thank you, Wendy, and good morning, everyone. My name is Shawn Smith. I'm a Strata Property lawyer. I've been practicing law for 25 years, and the vast bulk of that has been Strata. So I'm appreciate you joining me this morning. And we're going to talk about how to successfully conduct an AGM, or as I jokingly wanted to subtitle it, how to survive an AGM. So we'll see. I'm just going to share my screen and we'll just get underway. So just a little bit about our law firm. So Cleveland Doan is a full service law firm with a focus on strata property law, and we help strata corporations with everything that they deal with day in and day out. And we've got four lawyers, including myself, who practice in that area. Uh, so just before we start talking about the mechanics of the AGM, just wanted to go through some observations. A couple of quotes that I like when we talk about governance issues. One of those is from the TV show The West Wing, and the fictional President Bartlett. And one episode he says, decisions are made by those who show up. And I find that is entirely true with respect to strata corporations. Many stratas can struggle to meet quorum, and you'll have a handful of owners making the decisions that affect everyone else. The other quote I love when talking about governance is one from Winston Churchill: democracy is the worst form of government except for all the rest. And sometimes with stratas, that can prove to be true. So, one thing when we're talking about general meetings that I like to emphasize is that process is important. And that's really what we're going to spend time on today, is talking about process. How do we give notice? How do we conduct the meeting? How do we make decisions? And process is important for two reasons. One of which is I think it's easier to accept a decision you don't like if it's properly made. So I think if owners feel that the process has been fair, they've had their say, most people can live with a decision that or an outcome that they didn't really want. The other is a more practical one. And the easiest way to challenge a decision you don't like is if it wasn't properly made. So Wendy and I were commenting just earlier about there's a number of CRT decisions where if you read through them, you'll see that's the way that people have challenged decisions. Meetings are getting overturned, decisions are getting set aside because process wasn't followed. So it's important to follow process in order to make sure that that decision is going to be upheld. Although the discussion today is in the focus on AGMs, everything that I'm going to talk about applies to special general meetings and also to meetings held by sections. It's all the same process, same rules. So there's a few legislative things that form the basis for holding general meetings. So the Strata Property Act, Part 4, Divisions 4 and 5, which are sections 40 to 58. So those are the provisions of the act that talk about the giving of notice, the holding of meetings, and who has voting rights. You also the standard bylaws 25 to 28 deal with the process of running a meeting. So Strata Property Act is how you give notice, bylaws are how you run the meeting. Strata corporations can supplement those standard bylaws, so they can do things like change the quorum requirement, change the quorum waiting time. Some stratas even put in bylaws with respect to how meetings are to be conducted. So always, of course, check your bylaws to make sure that uh, that you know what they say in terms of conducting the meeting. We're going to start with talking about giving notice of the meeting, because this is really where everything starts. Uh, so it's important to note there are specific requirements with respect to content and delivery. So those are what are set out in the Strata Property Act provisions. And really, it's a matter of ticking off all those boxes. So improper notice can lead to meetings being overturned and set aside. So there's a number of cases, including the Shen decision that I've cited, that arose out of COVID. Everyone in the Strata community is struggling to figure out how to hold meetings. A lot of those ended up having to be redone because not all the boxes were properly ticked. So that principle applies the same today as it did then. If you don't get it right, Section 47 of the Strata Property Act is a saving provision. So it says failure to give proper notice does not invalidate a vote if a reasonable attempt to give the notice was made. What is a reasonable attempt is always open to some interpretation. Couple of cases involving the same owner and same strata have addressed that issue. So the first Kirk decision in 2008, the court recognized that an inadvertent mistake is saved by Section 47. So, for example, we'll talk about this later, giving 14 days instead of the required 20. A later case in that same series, the 2015 decision, the court said a deliberate and conscious decision not to comply is not saved by Section 47. So if you decide not to deliver notice to the place that the owner has directed or intentionally leave something out, it's not going to be saved by that provision. Talking about the specifics of notice, Section 45, sorry, just before we talk about the specifics of notice, waiving notice. So you actually don't have to give the full notice. Owners can waive notice in advance. You can hold a meeting in a shorter period. Note, though, that it can also be revoked, which is a bit of a risky uh, thing. An owner could revoke that waiver just before the meeting, and then you have to go back to square one. Section 45 sub 5 is also a saving provision. If you didn't give proper notice, owners can vote to proceed despite that. So practical only for a smaller strata corporation, not particularly practical for a large strata. Another thing to note with respect to waiver is that every owner on title has to waive notice. So it's not just one owner. Everyone on the title has to do that. Talk about the actual mechanics of notice. So Section 45(3) deals with the content of the notice, what's to be in it. Section 103, though, needs to be noted because that's the requirement that a budget and financial statements go out with the AGM. And then the particulars of what's to be in those financial statements and the budget are set out in the regulations. So you'd have to turn there and make sure that you have noted those and included everything in there. Because again, a failure to provide the details required could invalidate the meeting notice. Specifically, what the notice has to include is it has to include a description of all matters that will be voted on at the meeting. So this ties into this is essentially later on the agenda. What are we going to be discussing and considering? The key requirement there is that if it is a three-quarter vote, 80% vote, which is the windup, or a unanimous vote, which are rare things largely to do with amending the strata plan, the precise wording of the resolution has to be included in the notice. So, for example, if you're going to consider a bylaw amendment, you can't simply put in the agenda bylaw to limit pets. You actually have to have the text of what that proposed bylaw is. You also have to have the date and the time and the place of the meeting. So, when are we meeting? Where are we meeting? And if you are allowing owners to attend by electronic means, you don't need to, but if that is going to be an option or it is going to be an entirely a Zoom meeting, then it has to have the instructions. So, how do we get into the meeting platform? Notice also has to be neutral and restricted to the facts of the matter. So this comes from the McDonald decision that I noted at the bottom of the slide, and this can be tricky to do. You certainly have to set out some background as to why this resolution is being put forward, or if it's repair and maintenance. Why are we needing to do this? But keep in mind that it needs to be as kind of neutral and factual as possible. If council is starting to advocate for a particular view, then the court in McDonald said you have to either put an alternate viewpoint in there or leave it out and then just simply campaign for the outcome outside of the AGM notice. So who do we need to send notice to? We need to send notice to the people on title, so owners, and that is who's ever registered on title in the land titles office. Tenants who have been assigned an owner's rights, so that arises under Section 147 and Section 148 of the Strata Property Act. So there's situations where landlords can assign their rights to their tenant. A very rare thing, but it can happen. You'd also need to give notice to lenders who have given a Form C request for notification. So I think in my 25 years of practice, I could probably count on one hand the number of times that I've seen a Form C, but they are out there. What that does is it entitles the lender to vote on certain financial matters. And then complicating things a little bit further is the decision in Hall and Strata Plan EPS 2116. In that case, the court held that in certain circumstances, you'd need to give notice to purchasers. So are you aware that the unit's being transferred? Is there something in the notice package that might affect that purchaser? And we're talking about purchasers who are going to be owners by the time the meeting is going to be held. If they're not going to be an owner by the time the AGM is going to be held, then we don't need to worry about it. But this is sort of a transitional period. So that's something to keep in mind. If you're aware of a transfer when it's happening, there may be a requirement to give the owner or the new impending owner notice as well. The notice period, so this is what I like to call lawyer math. The Act says give at least 14 days notice, and in the law world, that works out to 20 days. So this is something that self-managed stratas often and quite understandably get incorrect. Because you look at that and say at least 14 days, okay, 2 weeks. The reference to at least adds 2 days to that. So that gets us to 16. That arises from the provisions of the Interpretation Act. So you add the day notice is sent and you add the day of the meeting. Then, and we'll talk in a moment about Section 61, how you give notice. When you give notice by certain methods, that adds 4 days to that delivery total. So if you mail it, slip it under the door of the unit, you're going to add 4 days. So that's why stratas usually give 20 days because you want to make sure that everyone's gotten notice in the proper time. If for some reason that gets missed, this comes back to Section 47. If it was inadvertent through inexperience, then the court may uphold the meeting despite having missed that. Section 61 of the Act talks about a number of delivery methods. And this is important because if you don't get it right, then notice hasn't been properly given. And these apply not only to general meeting notices, but they also apply to sending demand letters, any other notices to which an owner is required. So there's, I didn't mention it here, but there's a lien case where the court set aside the liens because proper notice wasn't given with the initial demand letter. So that case would apply quite clearly to general meetings as well. So several ways in Section 61 to give notice. You can leave it with the person, so physically hand it to the owner, leave it with an adult occupant of the strata lot. You can put it under the door or you can mail it to the address of the strata lot. That, of course, is not something you can do at the moment with the current postal strike. So, of course, you'd need to look at other options of getting notice to people. Uh, I've noted there, and this comes from the Manji decision that I was talking about giving notice. Registered mail is not mail. So you can't send notices out by registered mail, regular mail. There's no requirement, though, to show that the owner got it. You simply have to show that you put it in the mailbox. You can put it in a mail slot or a mailbox if you have access to it. You can fax it to the owner. So if they still happen to have a fax machine and a fax number, you could do it that way. Or, of course, you can email it to them. However, there's a catch or a caveat to the email. It has to be an email address that they provided for the purposes of receiving notice. So it has to be a clear direction from the owner that please send me notice at this email address. It can't just be the fact that they happen to have emailed you and you now have their email address that you get. You get to use it. One question I get asked on that is, can stratas compel owners to provide email addresses? My opinion on that is no, because the act it is permissive. It allows the owner to decide whether they want to receive it that way. There's another layer to giving notice, and that is with respect to a person who has provided an address outside the strata plan. So typically, this is going to be a non-resident owner. So if it's a non-resident owner, they can choose to receive email at the or notice at the strata lot. However, if they've given you an outside address, then you either have to leave it with them or you can mail it to that address. The Azura management decision, the court in that case held that emailing counts as mailing to an address. Now, I want to emphasize that applies only to non-resident owners. So it's not something that you can override that earlier provision about owners electing, and it's generally not considered to be the best practice. Again, you don't want to push the envelope giving notice lest the meeting be invalidated. Sometimes meeting times or locations have to change. If the strata does that, then it's required to give notice of that change. Posting signs, we've moved from this meeting room to that meeting room or this location to that location, posting them in the lobby, that's not going to be sufficient. So when I say giving notice, it's not a requirement to go back to the 20, give 20 days notice because you're going to change the location. It's simply notifying owners of that change of location. You have to do it in the same manner that you would have given notice. So if you slipped it on the original notice under everyone's door, you're going to go around and slip the change of location notice under everyone's door. So when you've ticked all of those boxes, your package is ready, you send it out, you've waited your 20 days. Now we're at the meeting. And we're going to talk about process from signing in to finishing off. So the very first thing that we do as a practice is we sign people into the meeting. Now, there's actually no requirement under the Strata Property Act to talk about a sign-in sheet or a process, but this is developed. I think everyone throughout the Strata industry uses a sign-in sheet, and it's a very practical way of seeing who's at the meeting. And there's two purposes to having people sign in. First of which is to determine quorum. So, do we have enough people to conduct a meeting? It's much easier to determine that, particularly in large strata, by simply adding up the people who have signed in. It's also to make sure that the people who are attending can vote. So it gives you a chance to confirm if someone says, yeah, I'm here for unit 101. Are they the owner? Do they have a proxy? Do they have a right to vote? Because it's only eligible voters who have the right to vote. Sections 53 to 58 of the Strata Property Act define what an eligible voter is. And we're going to look at that in a moment. The other thing to keep in mind is that the Strata Corporation can prohibit voting where it's entitled to register a lien. So it needs, first of all, needs a bylaw to do that. Secondly, a Strata Corporation is not entitled to register a lien until it has given a demand notice under Section 112 and the 20-day notice period has passed. So even if we have a bylaw running around the week before the meeting sending out demand letters isn't going to preclude owners from voting. It's something you need to give consideration to in advance of sending out the notice. I've seen several bylaws over the years that also prohibit owners from voting because they are because they owe fines or chargebacks or other amounts. Those bylaws are not enforceable because the act doesn't allow for that. It only talks about depriving an owner's right to vote in respect to a lien. So owners can vote. That's sort of an obvious conclusion. However, there are a number of alternative voters, other people who could vote on behalf of a strata lot. So we've touched on a couple of those already. A tenant who's been assigned voting rights. So that's a written assignment from the landlord to the tenant. Lenders, again, on certain issues, but only if there's a Form C. An executor or a power of attorney can vote on behalf of a strata lot. The power of attorney, one important thing to note there is the act talks about the owner lacking the capacity to vote. So just because I have the power of attorney for my elderly parent doesn't mean I can use that to vote. If they're still capable of managing their own affairs, they have to give me a proxy. Corporate representatives. So if you have a corporate owner of a strata lot, someone's going to come on behalf of the company. Sometimes you know who that is. It's the owner of the company. Everyone knows that. Other times you may need to have a letter from the company, if it's a larger company or a developer, appointing who this person, Shawn can show up and vote on behalf of the company. Of course, proxies, I can give my right to vote to someone else, and we'll talk in a little bit about proxies and how we certify and verify those. And then a court-appointed voter. So, in the odd case, if there was nobody on this list to vote on behalf of Stratalot, then the court could appoint someone. And again, I don't think in my 25 years I've ever seen that, but it's there. So when we're signing people in, confirm they're an owner. So it's important to keep an updated owners list to make sure that the person who shows up, you ask their name. If it's not on the list, they're not entitled to vote. So if you have multiple owners of a strata lot, make sure that your system, your sign-in sheet, your owners list reflects all of those people. You're also, again, checking to see, are they prohibited from voting due to arrears? So have we sent the notice? Well, back up one, do we have the bylaw? Have we sent the notice? Has 20 days passed? Also ask them if they hold proxies. Some people will show up and they'll give you all their proxies. Other people sign up and they just have proxies, but they don't sign them in. So ask them for that. Make sure they've got them. It's also important if your bylaws, which the standard bylaws do, talk about issuing voting cards, that you issue the voting cards. So this is one of the issues in the Shen decision was that voting cards weren't issued for the virtual meeting. You normally do not ask for ID when someone shows up. However, that's not necessarily precluded. So you have to think about HIPAA issues. Is there a basis for asking for that? So you'd have to, I think, have one. Have there been a lot of people showing up to meetings in the past, saying they're people and they're not? Is there some contentious reason why we need to be verifying ID? And of course, in a small building, that's not really necessary because you generally know your neighbors. So we'll talk about proxies, and proxies is probably one of the most contentious and problematic areas of the Strata Property Act or Strata Property Governance. Um, and there are some rules, but beyond that, yeah, it's a bit of a free for all, I guess one could say. And I get asked the question, can you limit the number of proxies? There's cases that suggest you can't. There's really no case law on that topic. My view, given some of the other case law that has arisen with respect to meetings and particularly restricted or directed proxies from the COVID period, is I don't think you can. I think at the end of the day, um, a bylaw to that effect would probably be unenforceable. Section 68, or sorry, 56 governs proxies. And it doesn't say an awful lot, but it sets out the basic requirements. So the first requirement is that the proxy must be in writing. So I can't verbally give a proxy. There's also some case law that says it can't be an email or a text. So I can't text Strata Manager, giving someone my right to vote. I can email in a scanned proxy, but an email in and of itself is not sufficient. So proxies in that sense don't need to be the original. They can be a scan so long as they meet all the other criteria. So first criteria, of course, is that it must be signed by the person giving it. So if I'm giving a proxy, I have to sign it. There are some other requirements, and this ties into when we talk about certifying a proxy. We're making sure that all these boxes are ticked. Um, so it must be, well, before we talk about that, we're going to talk about two other things. Proxy can be revoked at any time. So in writing, so I could send in a letter saying I gave my proxy to my neighbor Bob. I don't want him to have it anymore. It can be revoked by giving a new proxy. So typically, the practice is the proxy that's most recently dated revokes the prior proxy. If you end up with two proxies with the same date, then you really can't allow, or at least my practice, I don't allow either of them because we don't know which one was granted when. Or I can revoke a proxy by showing up. If I've given a proxy to someone, but I show up at the meeting, generally that's implied that I'm going to be voting. Not always. Some people do give proxies and show up and don't vote, but it's important then to make sure that their vote stays with the proxy holder. You can't give a proxy to the strata manager and you can't give it to an employee. So this can be sometimes problematic when you have an owner who's employed by the strata. So in what capacity are they receiving proxies? And probably best practice is not to give it to that person, period. And then proxies must be properly filled out. So the McDonald decision, you'll see I will reference that a few times throughout today's presentation, dealt with a lot of these procedural issues. And one of the things it dealt with was proxies. So the first thing it says, blank proxies are invalid. So if I sign a proxy, leave the name blank, and the proxy holder shows up at the meeting with no name filled in as to who's going to exercise the proxy, that can't be accepted. Um, and you can't send the person away to have them fill it in. They can't fill it in right then and there because the proxy holder's name must be written before it was signed. So if you are collecting proxies, that's an important thing to make sure that your name's inserted before the owner signs it. And any changes, so if there's a change in the proxy holder, that change must be initialed by the owner who's giving it. Proxy also have to identify an individual, so you can't say any council member. And building on that, you probably can't just say the president. It should be an owner's name that's in there. So any of those boxes aren't ticked, the proxy is not valid and cannot be accepted. So standard bylaw 28 sets out the order of a meeting, and that makes its way into the agenda. And the first thing on there is certifying proxies. So what does certifying mean? Uh, It really just means we're looking at how it was or was it properly completed. We're not looking at how it was granted. We're not going behind that. In fact, there's one case that suggests an owner could sell their proxy. Um, so it's not up to the strata to figure out how the proxy was granted and whether it was granted under appropriate circumstances. Certifying simply means we're checking all those things off. Is it properly signed? Is it completed? And has the owner given it? Uh, that occurs at the start of the meeting. Uh, you can request that people send them in early. That helps speed it up, particularly on a virtual meeting. But you cannot mandate mandatory or early submission. So there's one CRT decision that says if I show up with my proxy, I can Strata has to accept it. The proxy certification process uh, practically starts with the person who's signing people in, the strata manager or volunteer council members. And so basically what they're doing is they're going through and making sure all those boxes are checked, whether to accept it or not. Technically, it's the chair that certifies them. So the chair is going to accept the recommendation that these are the only proxies we've accepted. If there is a dispute with respect to two proxies, or the person signing in says it's not valid and someone challenges that, then that should be resolved by the chair and should really be resolved at the start of the meeting, in front of the meeting. So there's a formal decision made. Section 56(4) is also an important provision because it says what a proxy holder can do. So it can do anything that the person giving it can do. So full rights of the owners. They can move, they can second, they can vote. Anything that an owner could do, the proxy holder can do as well, unless limited in the appointment document. So if for some reason the proxy had a limitation, then that would need to be noted and observed. In theory, the Form A to the Strata Property Act, the suggested form of proxy, that could be a proxy just for one resolution. So if that box were ticked, that person can only vote on that one resolution. And just on that note, a proxy doesn't have to follow that form. It can be any form so long as it's written and signed. So we've gone through all the proxies, all the sign in, everybody's in their chairs. Now we have to determine quorum. So under Section 48 of the Strata Property Act, quorum is 1/3 of the votes. So in a residential straddle corporation, that is going to be 1/3 of the strata lots. However, remember that commercial strata lots often have more or less than one vote. So that could affect quorum, even though you have less than a third of the strata lots, you could in fact have 1/3 of the votes. The bylaws can amend quorum. They can set them lower or higher than the 1/3. If you're a smaller strata, three or less strata lots or three or less owners, then it's actually 2/3 of the votes to make quorum. And when you're determining quorum, we're only counting the eligible voters. So if someone is restricted from voting due to the fact the strata could register a lien, they can still come to the meeting, they can sit through it, but they won't be able to vote, and their attendance doesn't count towards quorum. Key provision of Section 48 is that you cannot you cannot conduct business if quorum is not present. So you can't start the meeting until 1/3 of the owners or 1/3 of the votes are present. Strata Property Act has a default provision that says, well, if you don't have quorum, then you're going to wait a half hour. And if there's still no quorum, you're going to come back the same day, same time next week. Not practical by any stretch of the imagination if you're trying to coordinate with strata managers, lawyers, engineers, other people, or if you had to rent or acquire a venue. Not necessarily going to be available same time next week. So most stratas, and it's something that we certainly encourage when we're reviewing bylaws, is you change that waiting requirement. So typically there's a bylaw that says you wait 15 minutes and then whoever is there proceeds. There's no magic. It could be 5 minutes, it could be half an hour. It's whatever you or the owners feel is comfortable and appropriate. So the fact that you cannot conduct business if quorum is not present doesn't just present a problem at the start of the meeting. It can be a problem throughout the meeting, particularly if you just barely got quorum. So beware of owners leaving. So if people are leaving, you could actually, in fact, lose quorum, and then the business has to stop. So if you can catch owners who are leaving, you may want to ask them to give a proxy to someone, which leads into sort of a common practice as it gets later into the evening. People start to want to go, and they just hand their voting cards to the neighbor sitting beside them. That's not permitted. If you're going to leave a meeting and you want to give your vote to someone else, then a proxy needs to be signed. And so that's something the chair needs to be looking for. And if there are other people, strata managers or council members assisting with the meeting, try and note that if that's happening. Next item in the agenda is choosing the chair if necessary. And the chair of the meeting is a very important role. So the chair must ensure that proper procedure is followed. So going back to my initial comments, we want to make sure it's done right because we don't want to have it challenged. They have to keep order, and I'll talk a little bit about some tips for keeping order, and they have to be fair. So by default, under standard bylaw 28, the strata president is the chair. If they're unable or unwilling, the vice president fills that role. If neither of them want to do it, then you must elect someone else to do it. Typically, if you're going to have someone else chair, we would want the meeting minutes to record that the president and vice president have declined. If you're going to elect a chair, it can be anyone. It can be the strata manager, it could be another owner, or it could be a lawyer. And often when I attend meetings, I'm elected to chair it. Sometimes the strata manager or someone else will step in as a facilitator. It's not a practice I'm keen on because they essentially end up acting as chair, but they technically don't have the authority to do so, which may not be a problem. But if there is a problem down the road, someone wants to challenge the meeting, it might be. So to elect a chair, but vice president or president and vice president have to either not be there or have to decline. Then someone's going to make a motion, second it, and vote by majority vote to approve and elect the chair. I always like that process because then it makes it clear that the chair has the authority of the meeting to act. I know sometimes I've been at meetings where people say, does anyone object? That's not the best process. Again, motion second, elect. The Kirsch decision, the CRT said, as a general rule, it's up to the chair of the meeting to run the meeting as they see fit, so long as they do so within the provisions of the SPA and the bylaws. And sort of as a general broad overview, I think that's correct. However, there are some other rules arising from other cases that do put some or set some requirements for the chair to observe. So a chair must allow discussion and participation. Owners must be afforded an opportunity to voice reasonable concerns. That doesn't mean that the chair can't limit the time for a person to speak, so long as it's a reasonable time. So you can't say, well, you got 30 seconds, but you also don't need to let an owner speak for half an hour. Reasonable may be based also on the topic, how it affects that owner, just a little bit of perhaps common sense judgment. Might would need to be applied by the chair in that sense. Again, McDonald talked about chairing. So an owner has a reasonable expectation to be treated respectfully and not denied the right to participate in the meeting. So the McDonald decision dealt with two meetings, the first of which the chair was very dismissive to Mr. McDonald. When he got up, the chair was like, "Yeah, okay, sure, yeah, yeah, if you want to talk, blah," and was very just condescending. The court took a very dim view of that and found it significantly unfair to that owner. In a subsequent meeting, the chair didn't want to allow Mr. McDonald to read large sections of the act into the record, and the court felt that that was appropriate to deny that, but still give him the right to speak. So the key, I think, out of McDonald is also not to be dismissive towards participants. Even if what they're saying or their behavior is grating, the chair needs to again be fair and neutral in that respect. So once we have a chair in place, they're going to move into the agenda and start the meeting moving through. So bylaw 28 sets out the order of business. So this is the agenda. It's council that sets the agenda, subject to anything that an owner or 20% of the owners may send in pursuant to Section 46 of the Strata Property Act. And then the agenda flowing from Standard Bylaw 28 requires the meeting to approve the agenda. What that means is you're simply approving the order in which things will be considered. So simply because they're set out in a particular order doesn't mean that the owners have to actually consider them, and that way you could move them around if there's some reason the majority thinks that we should consider item B instead of before we consider item A. So that again would be if the owners want to reorder the agenda, you've moved the agenda, you've seconded it, someone's going to move an amendment, and then that's going to be voted on. One exception to what you can move is if it's an owner demanded special general meeting, their items must be considered first. Approving the agenda doesn't allow you to add things to the agenda. So this goes back to section 45.3. Notice of what's going to be considered has to be in the agenda. Now, if you miss something on the agenda, but you included it in the notice package, that would probably be fine to formally move it into the agenda because it's in the package. It's before them, they're not going to be surprised by it. It's not clear whether you can remove things from the agenda. That's not something I'm keen on, but you could simply either vote later on to table it or simply not move and second it. Once you've approved the agenda, then we need to move through it. So this is now we're getting into a lot of process. So one thing is that there's no requirement to follow Robert's rules of order or any similar set of procedures. Just because those are out there, just because they're often used, doesn't mandate them for strata property use. The exception is that if you have a bylaw that says that, and if you do, my recommendation is to revoke it because Roberts is actually quite technical. And if you somehow didn't follow it, that could challenge the meeting. I use it though as a guide for what's fair. And certainly there's sort of summarized or summary versions of Roberts, and that's probably most appropriate for a strata meeting. What the case law has said is that simply stratas are required to follow fair and democratic general meeting procedures. And the Daniels decision, the Court of Appeal simply said the procedure needs to not be unfair. So again, have people had an opportunity to speak? Is what we're going through, or there's the decision at the end of the day reflective of the democratic will of the meeting? My view is the chair should communicate the meeting rules at the start of the meeting. So make sure that everybody knows how we're going to conduct the meeting. There's no need to approve or adopt a set of rules. You could, but then once you do, you got to make sure they specifically follow those. Some stratas do like to set out procedural rules in the bylaws, and some stratas send them out with the notice of the meeting so everyone's aware of them. Those are not mandated practices, but they may be something you want to consider based on your particular circumstances. Some basic rules that I like to use as the chair is address the chair when speaking. So no crosstalk. Sometimes owners want to talk to each other. I like people to speak to the chair because it helps keep tensions down. You're talking to me, you're not talking, and again, someone who's going to get agitated by it. Wait to be acknowledged before speaking. So we have a speaker's list and order. I usually ask people to only speak once if there's others who have not spoken, so you don't have someone who monopolizes the meeting. I generally say 3 minutes for speaking, but I'm not always particularly strict on that. You have to sort of, again, look at it. You want to be fair, you want to be reasonable. And then I ask people to respect my ruling as chair. So setting the expectation. I've been voted to chair this meeting and get us through this meeting, and I need you to respect my rulings in order to do that. As we go through the agenda, resolutions are typically moved and seconded, and then discussion. By convention, a resolution or motion which is not seconded is not dealt with. Same for if nobody moves it, then we won't consider it. But there's no particular case law or statutory provision that talks about that. Make sure, though, and particularly your job as chair, that you take a vote and it's recorded in the minutes. The Lewis decision, a resolution that's not formally approved is not effective. In that case, the Strata forgot to actually vote on their bylaw package. They approved one, and there seemed to be a consensus with respect to it, but nowhere was there a record that anyone actually voted to approve it. So the bylaws the Strata was relying on were set aside. Part of moving through the agenda is also taking minutes. Ideally, the chair should not be taking minutes, but someone else should. Um, Strata Property Act requires, Section 35 requires the Strata to keep minutes of annual and special general meetings, including the results of any votes. So the only thing that actually needs to be in the minutes is a record of the decisions made. That doesn't preclude other detail from being included, but they don't have to be. So that is also quite often I'll hear an owner say, I want it recorded in the minutes that blah, blah, blah. They have no right to do that. They don't have to be. The chair and the secretary don't have to do that. It's simply decisions made. So keeping order is going to be one of the chair's jobs. This is the point in the talk I thought we needed a wee bit of brevity. And so this is John Bercow, he was a long-standing speaker of the British House of Commons, who was famous for various ways in which he cried order. And sometimes at a meeting, your job is going to be very similar to keeping a raucous parliament in line. So some tips that I like to use or practices that I use for keeping order is stand when you're chairing. Don't sit, particularly if it's a large crowd. People can see you, you can project better, and there's simply a little bit of being up gives you a bit more authority, perhaps. Be calm, controlled, and respectful. That can often be very difficult to do depending on who you have in the crowd. But the chair's job, a part of keeping order, I think, is keeping the calm. Um, be firm, hold people to the rules. So if someone starts speaking when they haven't been acknowledged, you need to cut them off and say, sorry, the gentleman over here has the floor. You may speak after. And even the time limit, sorry, your time is up. You need to sit down. And don't allow people to speak out of order. I think that just irritates people who've been waiting if you let people jump the queue. Be neutral as chair. Your job as chair is process, not outcome. The outcome is the prerogative of the owners. If the council wants a particular outcome, then one of the council members needs to speak to that. The chair's job is to make sure that we get through the meeting, we follow process, and a sound decision, whatever that may be, is made. So stick to process. Check those boxes. I also try and earn the trust of the owners. So part of that is being fair. If you're asking people to respect your rulings, they need to respect that you're being fair and neutral. And sometimes don't be afraid to suggest it's time to move on. So gently say, I think we've had a sufficient amount of discussion on this. Are we prepared now to move to a vote? And that can be particularly important if you have a venue that has a time limit. You've got to get you got to get through it because you got to get out. Part of keeping order is also being aware of standard bylaw 26. Tenants and occupants can attend, but only allowed to speak if the chair allows them. And by majority vote, you can ask those people to leave the meeting. Sometimes you'll have difficult owners who just do not want to play by the rules, even though you set them out. So practice I like to make sure is we give clear rulings. You are out of order. Here's why. And also give clear warnings. So, I've asked you, sir, not to interrupt. If you do that again, I will have to, and then whatever you, chair, think is appropriate. One thing that you can do is ask for a motion to eject an owner from the meeting. And I've only ever had to do that once, moved and seconded, and the owner then recanted, agreed to behave. The movers and seconders agreed to withdraw the motion, and that person behaved for the rest of the meeting. So it's an extreme remedy, but it's there. So assuming you've kept order, we're going to move through the business of the meeting. Procedural motions are things that come up during the course of the meeting. And you can employ those, owners can employ those, the chair can ask or suggest that they be employed. And they really help, I think, assist with an orderly flow of business. They empower owners to control the process, and doing things by motion, I think helps make the decision making fair and democratic. Back to Daniels. Any procedural motions are going to be decided by majority vote because Section 50 sub 1 of the Act says that all decisions are by majority vote unless otherwise indicated. So I just talk about a couple that are commonly used. So a motion to table. So it's a decision to deal with, and sorry, that should say a resolution later on. So you could table that resolution to another time in the meeting, to another meeting, the next AGM, a special general meeting, or you could just generally table it. We're not going to deal with it. So that motion would arise. You've moved and seconded the resolution. You're in the middle of discussion. Someone could make a motion and then second it to table it. And then as chair, you would allow that motion to be voted on. And if it's successful, then the item is tabled till the time set forth in the motion. So it can be a way of really, if you're dealing with something and it becomes obvious that people want to discuss or deal with something further in the agenda, or they simply just don't have enough information, we need to come back at a different time and deal with it. You could table it. Alternatively, on that latter one, owners could simply vote it down. There's nothing that precludes a motion that's defeated from being brought forward again. Amending a resolution. So this is a way of permitting owners to fine tune things. Amendments are permitted under Section 50 of the Strata Property Act. So majority vote resolutions, there's no restrictions on them. So this is with respect to the budget. You can amend the budget up, down, sideways, as many ways as you'd like. There's no restrictions on that, so long as the majority of the owners approve that amendment. Three-quarter vote resolutions are a little bit different. You can only make an amendment to a three-quarter vote resolution, so a bylaw or a special levy, if it does not substantially change the resolution. So substantial change was discussed in the owner strata plan VR 2702, and the court concluded that it's concerned with the relative importance of the change in the context of the resolution as a whole. For example, if you had a bylaw proposal that limited pets to one dog, and then someone said, "Hey, I want to amend that and say no dogs," of course, that's going to be something of substance. We're going from dogs to no dogs, and that's kind of the best example. A lot of times, it's the chair is going to have to make a decision. Probably better as chair to err on the side of caution, because again, if the chair is wrong, allows a substantial amendment, the resolution of the bylaw could be set aside. Similarly, with special levies up and down, depending on what you're changing in the scope and the dollar value, that could make it a substantial change as well. So when you're dealing with amendments, the proposed changes need to be clear and precise. So what exactly is the amendment that's being proposed? Because sometimes owners kind of talk about what they think they want to amend, but we need to know what we're voting on. So sometimes the chair, particularly if it's the lawyer, is going to make a suggestion. This is how I think you want your amendment worded. Amendments, deal with them one at a time. So if someone wants to make an amendment, move it, second it, discuss it, vote on it. Technically, under Roberts, you can amend amendments. I really don't like doing that because you lose where you're at and create confusion. So I just generally don't allow that as a process. If someone wants to do something different, then we'll deal with the amendment on the floor and then bring up another one. So if an amendment is approved, then once you're done discussion and any other amendments, you have to vote on the resolution as amended. So as chair, don't miss doing that. Reconsideration is a perhaps controversial, but sometimes very helpful procedural motion. So this stems from the Lovey's decision. I was counsel in that case. And the court upheld the right of owners to vote to reconsider a defeated resolution. So this often comes up when we're dealing with building envelope repair issues. Owners vote a levy or a resolution down, and then there's some further discussion, and people go, "Oh, actually, maybe that wasn't the best choice. That was the best option. We should have approved it." So owners can procedurally vote to go back and vote on that resolution again. In the Detmers CRT decision, the tribunal said a vote to reconsider is not strictly necessary. My view is it's best practice because it really shows the democratic intention of the owners. So someone may need to make a motion, second, majority vote to reconsider, then you go back and then discuss and vote on the resolution that was previously defeated. So it's a new vote on that same resolution. Another very helpful tool is Section 27 of the Strata Property Act, by which owners can, by majority vote, direct the council. It's the only Strata Property Act referenced motion that can be made from the floor. The reason for that is you're not actually authorizing anything. So you can't authorize the spending of money. You can't, basically, you can't direct council to do something for which notice should have been given. What it's good for is it helps give council direction. So you can, by majority vote, direct them to call an SGM and put a certain resolution forward, or to put a certain resolution forward at the next AGM. So again, it arises often in building repair issues where council has put forward a proposed course of action. The owners don't like it. If I'm at those meetings, I usually try and get the owners to give some sort of direction formally because council needs to know what to do next. What should they be bringing forward? So it's a way of making sure that certain things can be addressed and dealt with, giving the owners some certainty rather than just hoping that the council will do so. And again, it's a motion, a second, and vote. Ending debate is also something that comes up. So often you'll have someone call the question. That doesn't actually obligate the chair to stop debate or discussion. And given the McDonald decision, I'm always a little bit hesitant about summarily ending debate as the chair. So I like to employ a motion to end debate, which is the procedural motion. So you can have somebody make a motion second to end debate. It's non-debatable. And then simply have a vote. And if a majority of the owners want to say, yep, let's move on to a vote, then the chair is going to move forward to the vote. But again, it's a democratic way of the owners saying we want to move on rather than the chair just imposing that. And then there's also a motion to adjourn. So adjourning is different than terminating. It allows the meeting to continue at another time, usually chosen by council. It's often employed where you're running out of time and you haven't finished the AGM. So you may have to adjourn and then pick up the meeting at a different time and date and location. It can also be used if things are just simply getting way overheated and everyone needs to go home and take a breather and come back at a different time. The key to it is it's the same meeting. So you don't give new notice. It's not starting the meeting over again. You're just picking up where you left off. The Daniels decision that I mentioned earlier about things not being unfair, I said formal notice of a reconvened meeting is not required. But again, I think that's a good practice. Once you've determined the date and venue for picking up, you should send that out the same way that you did the notice of meeting. Voting is pretty much the key reason why we're at the general meeting. We're voting to make a decision to do something. So I've already mentioned that Section 51 sets the threshold as majority unless a different threshold is met. So some common examples, three-quarter votes, special levies, bylaws, unanimous votes. Maybe you need to amend the strata plan. So unless there's a section that sets a different threshold, majority is by default what we're going to do. Majority vote and three-quarter vote resolute or definitions in the act set what it is. The key to them is that it says owners who have not abstained from voting. So that's very different than if you're a Robert's Rule of Order buff. Abstentions are usually no's. In strata property, abstentions simply don't count. So what that means is that you could have 15 yes, 10 no's, 20 owners abstained, and the resolution still passes if it's a majority vote because we're not counting the abstentions. So that's why it's important also when you're counting votes to ask for the abstentions. We have to know where everybody sits because we're figuring that threshold out based on the yeses and the no's. Another quirky voting thing to note is if you live in a mixed use building, commercial and residential strata lots, when you're dealing with bylaws, you need a three-quarter vote of each group in order to pass a bylaw. So this applies to buildings whether they're sectioned or not. It's just if you have non-residential or what are commonly called commercial and residential, and only with respect to bylaws. It does not apply to levies, budgets, anything else, just when passing bylaws. So if you have commercial owners represented, residential owners represented, and we're voting on a bylaw, you have to take the commercial vote, the residential vote, each must pass the bylaw by three-quarters. A failure to do so actually invalidates the bylaw, and that's the Omnicare decision. That also means that if the commercial owners simply don't show up, you don't have the positive three-quarter vote, you can't pass the bylaw. So if you're in a strata that has commercial owners that routinely don't show up, you'll need to get, I think, try and get their proxies for anything that deals with a bylaw amendment. Standard Bylaw 27 deals with voting process. So again, votes are decided on a show of voting cards unless an owner requests a precise count. So voting cards are important because that actually allows an accurate count because quite often you'll have spouses or co-owners of the unit show up. If we're just doing hands, people can put up as many hands as they want. We don't really know who has the right to vote and who doesn't. So that's why voting cards are used. So I would say a show of hands is actually non-compliant if you're taking a vote. If someone requests a precise count, then it's up to the chair to decide what method is going to be employed. So that could be simply still showing voting cards, but we're going to go around and do 1, 2, 3 and make the precise count. Despite any of that, if someone asks for a secret ballot has to be conducted. And there's a very, and sorry, that does not apply though to virtual meetings. So Section 49.3 exempts that. If we are going to do a secret ballot, there's a very specific process set out in the IMBO decision. And essentially, it's you have to have a location for them to mark the ballot and deposit it in the ballot box. Merely giving the owner an option to mark them privately is not enough. You actually have to make them do it that way. So the Cole decision for a BC or CRT decision from 2018 basically approved the process that the Strata employed. It's a very cumbersome process. Everyone comes up one by one, and cast their ballot goes back. So one thing that we do when we do bylaw packages is we delete the reference to secret and simply put ballot. So that relieves you of the obligation to have this voting booth process. It's simply mark your card, fold it up, put it in the bin. But again, process. If you don't follow the process, it could invalidate a decision that's uh, been made. So general tips for the chair. So you don't actually need to do a count unless requested. You can survey the room and make a call that it's a majority, and sometimes that's very obvious. Uh, if you are going to, or when you're doing a vote by voting cards, call for those in favor, opposed, and abstention. So again, you get a sense about um, what group we're counting the threshold out of. And then I always ask people to raise their voting cards high and keep them up and don't put them down until they've been asked to lower them, because you get people going up and down and you don't know whether they're voting yes, whether they're voting no. I kind of tongue in cheek remind people it's not an auction. We're not just flashing our voting card. Put them up, keep them up so we can get a good, accurate view. I also tend to employ summarizing what a yes or a no means, particularly on a more complex resolution. So you have to be very careful. You have to be very neutral on this. You don't want to be swaying people. But sometimes it's just a very, like, if you vote yes, you're approving the bylaw to say no dogs. If you vote no, then you're not wanting to ban dogs. Something like that, because sometimes. Um, People are not entirely sure what the yes or the no means. Uh, Sometimes the chair needs help, particularly on a ballot vote. So scrutineers are often employed. It's the chair who has the right to appoint those, and there's no need to vote to approve them. Uh, One thing to note also with the voting is that the authority of the chair ends once the meeting ends. So if it's subsequently discovered that the chair made an error or there's a miscount, the chair does not have authority to change that post meeting. It would have to be changed by the CRT or the court or by the owners at another meeting. Tie votes is something that sometimes happens under Standard Bylaw 27. The president has the tie-breaking vote, vice president, again by default. That power, however, does not transfer to the chair. So just because the president doesn't chair doesn't give the, doesn't mean that vote transfers to the chair. So you could have a different chair. If you get a tie vote, the president, in their capacity as president, can still cast that tie-breaking vote. All right, we're coming to the end of the meeting and also towards the end of this talk. And with many things, we save the best for the last, and often the last event at the AGM is the election of strata councils. Sometimes it's very simple, sometimes it's very complicated, sometimes it's very controversial. Section 25 of the SBA says that at each annual general meeting, the owners must elect a council, and that will show up in the agenda, in Standard Bylaw 28, in the order of business. But what does it mean to elect a council? So that was considered in Yang and Remax Commercial Realty. The court said it's the process of selecting a person to occupy an office. So that's what we're doing when we are voting in a council. There's no mandatory process for doing that set out in the Strata Property Act or the bylaws, but there's several methods that are employed, some better perhaps than others. So the options that most commonly get employed is the ballot. So you have a list of candidates. Your bylaws are going to set out a range of council members, 3 to 7 if it follows the standard bylaws. People are going to write down the candidates that they want to elect. So it could be one person, could be 7 people, could be 5 people. That's up to each person. The ballots are collected. The ballots are then sorted out and counted. It can be a very cumbersome process, but that's how we go through and determine who has how many votes. And I'll talk in a moment about the majority threshold. Another option is to elect a slate. So if you have 5 people nominated, there's but 7 positions. There's no reason or need to necessarily go through balloting. Someone could make a motion and say, I move to elect all 5 candidates to council. That needs to be seconded, and then by majority vote, the owners can elect them to council. The court said acclamation is a form of election, but they did say it's not the best process. And so if you have a group of people going to serve on council that everyone's happy with, I always just ask for that motion to elect as a slate. Then we make sure that they've been properly elected and avoid any controversies with respect to acclamation. So when I say properly elected, this comes back to section 50 sub 1 and that all decisions are made by majority vote. So I always like, no matter what method we're using to elect council, that we come back to a majority vote somewhere, somehow, that approves the process. So that could be the slate, as I mentioned, or if we're using a ballot, then it's only those candidates who've received more than 50% of the votes could be elected. Now, if you want to say the top 7 candidates, then that would need to be a motion and a second and majority vote approval to do it that way. And so again, it's preferable in the Primo decision, the court said it's preferable to vote on how you're going to proceed. I don't think that applies if we're just going to do the traditional ballot majority, only those who receive a majority. If the chair announces that, I think that's fine. But if you're going to do anything beyond that, then definitely I think a vote to come back and ground that election in the act. Nominating, there's no need for advanced or formal process. Of course, you could put that in the bylaws, but it could prove to be cumbersome. You can nominate yourself. I always like to make sure that the person nominated is willing to stand. So I usually say, unless they're there at the meeting to accept the nomination or they've given something in writing saying they would, then we really shouldn't be accepting the nomination. And definitely make sure that whoever is being nominated is on title or otherwise able to be elected. So, do you have a bylaw that allows for the election of non-owning spouses? Do you, or has a tenant been assigned an owner's rights? Because the last thing you want to do is elect someone to council who's not supposed to be there. That creates a number of problems and questions with respect to the validity of council. And then we get our council elected. We wish them well on the upcoming year, and then we're going to finish up our meeting. So the best practice is a motion and a vote to terminate. Make sure that the owners have decided to end business. It's usually the only motion at a meeting that gets unanimous consent. Everyone's ready to go home by then. Uh, Destroying the ballots is always sort of a question mark. There's no requirement under Section 35 of the Strata Property Act to keep them, so the Strata could just throw them out. It's common practice, though, to have a motion to destroy them, but that doesn't necessarily mean, if that doesn't happen, doesn't mean that they have to be kept. And then minutes, of course, have to be kept. But oddly, there's no requirement under the act to circulate them. The only thing is that you have to notify people of the strata fees. So typically that's done through the minutes, and it's just sort of common practice and common courtesy to let people know what's happened with respect to the meeting. And it's particularly important when you pass things like levies. People need to know that it's due. So the meetings vote to terminate, and that ends the night. And that ends my quick cavalcade through conducting or surviving a special general meeting. And I'm happy to take some questions.
Okay. I've been looking through the Q&A. There's lots of questions, and I'm wondering if we can do a rapid fire.
Okay.
I've separated
Let
the
me
question.
let me have another sip of water.
Yeah, this is going to be fun, Shawn. So,
Okay.
giving notice by email. Do you need a form? Do you need a letter? How official does that permission have to be?
It has to be something that the owner makes clear that they want to receive it by email. So I think probably best practice is, yeah, a form. And because in theory you could say, well, I want to receive notices of meetings by email, but I don't want to receive notices of bylaw violations. So a form makes it clear when someone's filled it out, signed it. Um, there it is, but it could just be an email. Hey, please send me the notice at this email. But make sure you've updated those because people sometimes change emails. You don't want to be sending it to the wrong one.
Mozilla members can log into your account and go to member resources, and we have a draft form that you can edit for your own strata. Okay, next, can you put voting cards in the notice package? I'm interested to see how you would answer this, Shawn.
No, because you have to make sure that the person you're giving the voting card to actually has a right to vote. So going back to the if you have a bylaw that deprives the right of an owner to vote if the strata can file a lien, you don't want them to have a voting card because if they show up, they even if you don't sign them in, they can pull out their voting card and be voting. So no, I would not do that. I know that happened a bit. Again, COVID, we tried to get around some things, but as a normal practice, no. And for virtual meetings, you don't need voting cards. That's not a requirement. So I would not do it.
This is going to be quick because you covered it. Are owners required to give proxies in advance a copy of their appointment form to the manager or the council before the meeting?
No. So it might be a good process, particularly virtual meetings help sign everyone in quicker, but no, you can't require that. And if someone shows up, and particularly if people show up late to meetings, you don't want to be restricting those rights.
Okay, so notice package. What if you forgot something that's actually a requirement like approving the budget? When you get to the meeting, are you allowed to add that to the agenda?
I would think if the budget is in the notice package, I would say yes, you could, because you've given notice in the sense that it's there. Um, if you didn't put it in there and you didn't put the package, if it's not on the agenda, not in the package, I think you've got a problem because you haven't given proper notice. So you'd have to go back to square one and give 20 days notice and start over again.
If something like discussion isn't an item listed in the notice package, it's no vote, could you at the meeting have a discussion period?
I think you could, because again, you're not conducting any business. You're not making a decision in discussion. And I always try to just a note on that. I try very hard to remind people that it's about general issues. It's not complaining about my front door or my patio. Like particularly when you got a lawyer there, it's great to move people along. I remind them of my hourly rate, and they 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 talk fast.
Interesting one. In our bylaw, in the standard bylaws, it says give reports. If the reports were given in writing in the notice package, do you have to go through the reports deep, line by line, or can you just say, are there any questions about this report?
Yeah, I think you can just enter them into the notice or into the record of the meeting. People could ask questions. Uh, there's no real formal outline on that. Certainly, I don't think you need to read something that everyone could have read.
On to voting. If someone were to give a proxy appointment form, the owner has signed it, but they haven't filled out any other information, is that a valid proxy?
So the proxy form does not have to contain voting instructions. It could, but it doesn't have to. So ultimately, that's between the person giving the proxy and the proxy holder with respect to what instructions, if any, they've given. But you can't refuse a proxy because it doesn't have those. I even sometimes question about voting instructions, whether Strata now has a requirement. If it's on there, Strata now have a requirement to make sure that's voted that way. So I don't like them as a general rule, but certainly you can't refuse it.
But if anything else is blank, the
Yeah,
name of
so
your
so
proxy
name of the
or,
proxy
yeah.
holder has to be signed, has to be for the right meeting. I didn't mention that, but I've seen it where someone brings a proxy from an old AGM package, and it says for the meeting that was like last year's meeting. You have to watch for that sort of stuff too.
Just to repeat, if the meeting is 100% held electronically, do you have to issue voting cards?
No.
Other than elections, are there any votes that you could do by acclamation?
No, because acclamation, if you look at in the Yang case, the court actually pulled out dictionary definitions of acclamation and it applies only to election. Um, so you don't want to do things by maybe consensus is the word as opposed to acclamation. You don't want to do it that way, or going back to the Lewis decision, you want to clear that, yeah, we voted on this and it's been approved. Otherwise, you run the risk of it being set aside.
If I was attending an electronic meeting and I had a couple of neighbors with me because they don't have a computer, we can still all vote on the motion. We just have to have a method of voting.
Yeah, yeah, and that becomes more problematic. But yeah, you could do it. You just have to keep track of who's voting and how.
Who's voting? Yeah. Let's say the notice package set out the voting procedures. And there was a resolution, not elections, but some other resolution that it said this one will be voted by secret ballot. What if you
Uh,
get to the meeting and somebody doesn't want a secret ballot? Can you change the voting method?
well, you could put that in there, but technically you can't. It's the chair who determines what the method of precise count is. And then if someone has to technically request a secret ballot. So what I've done is if council says we want to do this by secret ballot, I just make sure that someone has requested that. And then it goes that way. So you could put it in as sort of a heads up, but simply because it's in the notice package doesn't oblige them to to do it that way.
Minutes. You said that at the very end, you said there's actually no requirement to circulate them. Is there a requirement for the date that they have to be prepared by?
Um, well, you have to keep a record of the minutes. So I think it's implied that that's going to be pretty quick because someone could, in fact, request, I want to see the minutes from the AGM. If you don't have those available, then you've not complied with Section 35. So I think there's a bit of, of course, reasonableness is the implied standard in the Strata Property Act. If it's the day after the AGM, it's not, it's unreasonable to expect the council's going to have them. If it's 6 months later, um, and there's no AGM minutes, you haven't complied with Section 35. You don't have your record available.
And some bylaws actually address a time frame.
Yeah. So the bylaws specifically address standard bylaws address council meetings, but you could put that in for any general meeting. So similar, all of those procedural things, if you want to address those as a strata, you can put that in your bylaws and and then set out what and how you want to deal with that.
This is always a tough one. How much detail has to be in those AGM minutes?
The minimum requirement is the results of the votes or decisions made. So move, second, discussion, voted. When you start to wander too far, you always have to look at, are there potential PIPA issues? you have to look at. And I know this comes up with council minutes. There's been some cases where, council says nothing about some things, and then they get on to the difficult owner and they spend 2 pages explaining why they're terrible, and that gets them in trouble. So kind of keep them, I think, to a minimum. Certainly you can use them to inform people. Maybe, there was general discussion about the roof replacement and owners. In the consensus seemed to be that owners wanted council to move forward with the project next year, like that sort of thing. Keep in mind also that minutes can get circulated amongst the public. So buyers are going to look at them. They're going to be out there. So you also don't want to have too much of the dirty laundry, I think, being aired.
Just keep them professional
Yeah,
and imagine your mother's reading them, right?
good advice.
So thank you everyone for joining us and have a great day. Thank you, Shawn.
You're welcome. Bye bye.